Good afternoon, everyone. My name's Tim Fortier. I'm the Communications Coordinator with New Hampshire Municipal Association, and you have joined us for our 2022 webinar series. And this one in particular is House Bill 1661, What Local Land Use Officials Need to Know. Today, we are joined by our two presenters, Natch Greyes, Government Affairs Counsel with the New Hampshire Municipal Association. Good afternoon, Natch.
Good afternoon, Tim, and good afternoon to the many hundreds of people on this Zoom webinar this afternoon.
We do have a lot. And Noah, if you could advance the slides so that our attendees could see our presenters. There you are. There's Natch and Noah Hodgetts, who's the principal planner with the Office of Planning and Development within the Office of Business and Economic Affairs. I hope I got that right, Noah, but welcome here this afternoon.
Well, thank you very much, Tim, and thank you all for joining us today.
We are do have over close to 500 people registered for this webinar today. We have close to 300 in attendance already. We would ask that our attendees be judicious with the questions that we need to ask our presenters. We do believe that this webinar will go beyond the hour, so we are prepared to go and answer as many questions as we can in that time frame. So with that, I'd like to turn the program over to Noah Hodgetts to begin this presentation.
Oh, great. Well, thank you so much again, everybody, for joining us today. Today's webinar will first cover a review of the housing provisions contained in Section 70 through 79 of House Bill 1661, referred to by some as the Community Toolbox Bill, as well as House Bill 1021, which exempts religious land uses from zoning. I will cover Section 70 through 76 of House Bill 1661, and then turn it over to Natch to discuss Section 77 to 70 through 79 of House Bill 1661, as well as House Bill 1021. And as Tim mentioned at the outset, feel free to put your questions in the chat box throughout the presentation, and we'll do our best to kind of get to questions for the relevant section of the presentation as we go through the webinar. So before I review the specific housing related provisions in House Bill 1661, I want to spend a few minutes reviewing the road to passage of these housing provisions. In the summer of 2019, Governor Sununu convened a housing task force consisting of members from state agencies and entities, including BEA, New Hampshire Housing, and my predecessor agency, the Office of Strategic Initiatives, OSI, as well as municipalities, developers, and a bipartisan group of state legislators, who were all tasked with coming up with a plan to address the state's growing housing shortage. In fall 2019, this task force published a set of recommended legislative changes to address the housing shortage, including additional training and tools for communities. These recommendations were incorporated into House Bill 1629 and House Bill 1632 in 2020, House Bill 586 in 2021, and Senate Bill 400 in 2022. After much negotiating, some provisions of Senate Bill 400 were attached to House Bill 1661 during this past legislative session. House Bill 1661 was then signed into law on June 24th, 2022. And notably, absent from House Bill 1661 compared to earlier versions of the bill, were the option for communities to adopt mandatory inclusionary zoning under RSA 674:21, as well as the creation of a Housing Champion Community Certification Program. Section 70 replaces existing language on permissible training for new planning board and zoning board members offered by my office, the Office of Planning and Development, OPD, which is outlined in RSA 673:3-A, with new language which clarifies that any planning board or zoning board of adjustment member, including alternate members, may receive training from OPD or other organizations such as NHMA, which also offers similar training. Section 70 also added a requirement that OPD needed to prepare corresponding tests for planning boards and zoning boards of adjustment, along with our existing self-study materials. which are available on the OPD website. This change will go into effect on August 23rd, later this month. In accordance with Section 70 of House Bill 1661, OPD has developed a 30-question planning board test as an optional learning check based on the information contained in the current planning board handbook published by OPD. Unfortunately, due to administrative staff constraints, we no longer are able to offer printed versions of these handbooks for purchase by municipalities. However, we've included a link to download an electronic copy of the planning board handbook from our website. And I'm also going to put a link to the handbook in the chat right now for all to see. Hopefully that went out to everybody. We plan to publish an updated version of the handbook, which includes changes through the end of the 2022 legislative session by the end of this calendar year. Now, when taking the planning board tests, individuals will have the option to receive an email certificate showing that they passed the test by receiving a score of 65% or higher. To receive a certificate, individuals will be required to submit their name and email address. Please note, OPD will not be tracking names and scores for tests. However, for anyone that would like to take the test anonymously without having to submit their name and email address, we've created an anonymous test without a certificate. Links to the planning board tests with and without the certificate are shown on this slide. Links to both versions of the planning board tests. Well, I will also put a link to both versions of the test in the chat as well now. Let me see if this, just give me 1 second to copy these in. So that first link is to the one without the certificate. And the second link that I'm going to put in the chat now is the link planning board test with the certificate. And hopefully I put in, yep, both different links. OPD has also developed a similar 30-question zoning board test based on the content in our current zoning board handbook. The link to download an electronic copy of the zoning board handbook can be found on this slide, as well as, again, I will put the link to the zoning board handbook in the chat. And I'm also going to put in the links to the corresponding zoning board tests with and without the certificate. Just give me 1 second to do that. That's the first one. And first one is without the certificate, and the second link is with the certificate. Great. And those, yeah,
so
go ahead.
Noah, I actually have a question somebody submitted to indicate that on the attendee side, the chat is disabled, but we will make sure that you all have these links, and I will double check and make sure that the PDF version of the PowerPoint that was sent out earlier today by Tim has live links in those. And if not, we'll make sure to update those so that all of you can go directly to these links that Noah is talking about.
Great. I'm very sorry about that. And I also note that OPD did send out guidance last Friday, I believe it was, with these links to these tests, and we will also be posting these on the applicable website pages on our planning board and handbook, zoning board handbook website pages, as well as our planning and zoning training page as well. So we'll make sure that the links get distributed far and wide. Section 71 requires that any fee which the city or town imposes on an applicant shall be published in a location accessible to the public during normal business hours, or the fee shall be waived. A city or town may comply with the publication requirement by publicly posting a list of fees at the city or town hall, or by publishing a list of fees on their city or town internet website. A separate document labeled as Notice of Land Use Board fees under RSA 673:16, common Roman numeral 3, should be created that provides a complete listing of fees charged for land use board applicants before the planning board, zoning board of adjustment, historic district commission, building inspector, and building code board of appeals. And this change will go into effect on August 23rd, 2022. Section 72 of House Bill 1661 gives municipalities that offer increased density, reduced lot size, expedited approval, or other dimensional or procedural incentives to housing for older persons until July 1st of 2023 to make any adjustments to those incentives before they automatically apply to developments of workforce housing as defined in RSA 674:58, Roman numeral 4. These incentives are most likely to be found in age-restricted or elderly housing-based zoning districts, and age-restricted or elderly housing overlay zoning district or cluster development ordinances. Any incentives provided to housing for older persons as defined in RSA 354-A:15, Roman numeral 8, which are not offered to other types of housing or land uses, would qualify as this type of incentive. Municipalities that provide these incentives to housing for older persons in their zoning ordinance or other land use regulations should review these incentives this fall to determine whether amendments should be proposed at town meeting 2023. If a municipality that provides these incentives decides not to make any changes or put up zoning amendments at town meeting in 2023, then these incentives will automatically be provided to projects which meet the definition of workforce housing under RSA 674:58, Roman numeral 4, beginning July 1st, 2023. And Natch, have we gotten any questions on either of these two sections yet from folks before I move on?
Yes, I have one clarification question on 71 as to
Okay.
whether the publication of fees includes building permits and other select board fees.
So 71, and I'm gonna, sorry, that was my summary that I pulled up momentarily. So 71 directly says, refers back to existing fee statute. So it does, I believe, include the building permit fees. I do not believe it applies to select board fees. That would be separate.
Yeah, I agree with you, Noah. I think it would be any of the fees within the land use statutes.
Yeah.
So if you have some sort of separate select board fee, that would not be included, but something you would, you'd go to your building inspector for your plumbing permit, whatever, that would be part of it.
Great. Okay. Moving on to section 73, which has to do with written findings of fact. Section 73 expands the existing language in RSA 676:3, Roman numeral 1, requiring all local land use boards, which include planning boards, zoning boards of adjustment, historic district commissions, building inspectors, and building code boards of appeal, as well as agricultural commissions and housing commissions, to provide specific written findings of fact that support an approval or disapproval. But we note that the degree to which a local land use board should make these detailed findings of fact in support of an approval may vary based on the level of controversy associated with the application. If there's a level of controversy, the board should consult with their town council to prepare complete and legally sounding findings of fact. In general, the board should be clear with identifying how the application meets their regulation and checklist requirements for the findings of fact portion of the approval. We also note the findings of fact should not replace conditions of approval. For denials, a local land use board should consider what are the things about the application that are preventing it from saying yes. These things or factors should be anchored in the standards of the regulations and describe how the application does not meet the standards of the regulations, but may also include the exercise of independent judgment, experience, and knowledge of the area by the board. The findings of fact should be complete so that 1, a reviewing court knows all of the reasons for a denial, and 2, the applicant has instructions if they want to try again for approval a second time. The board should always enlist their town council to aid in the issuance of the findings of fact. And the kind of big change here is that failure when if a board fails to make specific written findings of fact supporting a disapproval, that shall be grounds for automatic reversal and remand by a superior court upon appeal, unless other grounds exist for disapproval. And this change will go into effect for August 23rd. And August 23rd later this month.
Noah, can I just add one thing in on this,
Please.
on the written findings thing? So on our practice pointer, we really want to emphasize the point that as a local land use board, you would be sitting essentially in a quasi judicial capacity. So you're acting in the capacity of a judge, you're deciding, you're resolving an issue really between two parties, whoever the applicant is and the abutters, and deciding whether that's appropriate based on the rules that apply, which is your zoning ordinance. So if you're going to deny an application, whether that's if you're on the zoning board, they fail to meet the variance criteria, or whether there's, on the planning board side of things, there's something specific within your zoning ordinance that they wouldn't meet the criteria for, you have to explain what you're doing, just like a judge would, because of course the next step in the process, if someone wants to pursue it, is to appeal it. And the next step in the process, the appellate court, whether that ends up being a ZBA if you're the planning board, or whether that ends up being the superior court, needs to understand what the exact reason is for the denial, and then apply the applicable law, applicable ordinance to that reason and make sure it applies. So that's really what we were trying to flesh out here with the practice pointer. I just wanted to really emphasize that because it's something that seems to those of us who are attorneys, this is what we do a lot. We love to have all these written explanations, but I recognize that most people on this call are not attorneys and they wouldn't necessarily be familiar with this type of process.
Great. And I know this has been we've received some past questions on the written findings. So are there any questions you're seeing, Natch, about the written findings before we keep going to the next section of the bill?
We're getting a lot of questions, Noah, faster than I can read them, unfortunately.
Okay.
So I think we should move on at this moment.
Okay. Okie dokie, we can come back. Great. Section 74 provides that a zoning board of adjustment has 90 days to begin consideration and approve or disapprove of an application unless the applicant agrees to an extension. If the ZBA determines that it lacks sufficient information to make a final decision on an application and the applicant does not consent to an extension, the board may deny the application without prejudice, allowing the applicant to reapply for the same relief. And this change will go into effect on August 23rd, 2022. And this is the first time, previously there was a clock on planning board decisions, which we'll discuss in a minute on the next slide. There was not a clock on how quickly ZBAs had to issue decisions. And so this section of the bill introduces for the first time a time period of how long ZBAs have to issue decisions. Next section, section 75, continues to allow a planning board under RSA 676:4, Roman numeral 1, parentheses C, to have 30 days to determine when an application is complete, but clarifies that the statutory time frame for acting on a completed application is 65 days. The previous iteration of statute did include the 65 days, but as we'll discuss in a minute, there was an option, more of an option, which has been removed from the statute to extend beyond the 65 days. So note that 2021's House Bill 332 which was also signed into a law and is in effect, extended the planning board's deadline to act by 30 days when the planning board determined development was one of development, a DRI, or a development of regional impact. House Bill 1661 introduced a grammatical error into the statute. However, there was no intent on the part of the drafters to remove the additional 30 days for DRIs, and the statute should continue to be read to include the additional 30 days in the cases of DRIs. As such, the planning board has a total of 95 days, 65 plus 30 when it's considering developments of regional impact to act upon the application. And this change, unlike the other section of the bill, will not go into effect until January 1st, 2023. So in the case that a planning board determines, again, we're still on section 75, that it lacks sufficient information to make a final decision on an application, and the applicant does not consent to an extension, the board may deny the application without prejudice, allowing the applicant to reapply. If the planning board does not act on the application within the 65-day period, then the governing body, being the select board or city council, is required to approve the application. And failure of the governing body to approve the application would then allow the applicant to appeal to the Superior Court, which must then act within 30 days and may order the municipality to pay the applicant's reasonable cost, including attorney fees, if it finds that the governing body's failure to act was unjustified. So, Natch, I'm going to pause again and see how we want to deal with questions.
So, Noah, there were a number of questions on section 72. I apologize, but I've just seen some of those. There's a little bit of confusion about how that incentives for older persons translated into incentives for workforce housing beginning July 1 of next year. Could you just kind of reiterate that for people? There were several people who were a bit confused.
Yep, sure. So essentially on section 72, for the purpose of a developer applying under the workforce housing statute, as I just said, as workforce housing being defined under 674-58 :58 Roman numeral 4, if a community has age-restricted housing provisions on the books, either in their zoning ordinance or other land use regulations, those incentives, whether they be dimensional incentives, timing incentives, density incentives, will automatically be deemed applicable for all developments that are applying as workforce housing under the workforce housing statute beginning July 1, 2023. Now, while it isn't stated in the language of that section of section 72, I think it really is a best practice for any community that does not plan to make changes to their age-restricted housing because they don't want the provisions to carry to workforce housing. Obviously, every community has that option. But if for any community that doesn't plan to make changes, it wouldn't hurt to make sure that those you clarify in your ordinance that those requirements for age-restricted housing, whatever those incentives may be, also are also kind of stated out in your section if you have a section on workforce housing as well. Hopefully that answers the question.
Thank you. The other question that seems to be popping up a lot is there's some confusion on section 74, the ZBA timeline, and 75, the planning board timeline, as to when the 90-day clock starts and when the 65-day clock starts.
Yep.
So if you could just explain that briefly.
Please. Yeah. Let me just again pull up my written version of the bill here. So on the ZBA section 74, that begins upon 90-day clock begins upon receipt of the application. So there is no extra 30 days for completeness. The 90 days is from when the ZBA actually receives the application. on the planning board timeline, there is the still 30 days for the delivery of the application, and then 30 days for it to be deemed complete, and for the board gets it, it's complete. And then once it is deemed complete, at that time that the board has it, the time that the planning board has the completed application in its possession, at that time, the 65-day clock would start.
Thank you, Noah. I think we can move on to the next section if you'd like.
Great. Okay, so now we're up to section 76. So section 76 eliminates the ability of the planning board under RSA 676:4, Roman numeral 1, in parentheses, subsection F, to request an extension from the governing board to take final action on an application. So as I said previously, prior law did allow a planning board to petition the governing body, being the select board or the city council, to extend the time to act on an application by up to 90 days. So now, instead, now the law reads, or will read as of August 23rd, that the planning board has no more than 65 days or 95 days in the case of the DRI to act upon an application. And the applicant, however, the applicant can waive the statutorily specified timing period. And if the applicant waives that 65 days specific time period, the board and applicant can then mutually agree upon a certain time extension. But again, the applicant has to agree to that extension. And this will take effect on August 23rd.
Just briefly, there are a number of questions about whether there will be templates provided for planning boards and zoning boards for some of the things that we're discussing today. I think it might be a little, I don't know that that your organization is planning on providing new templates or anything in the new publication that's coming out in December or not, but I thought I would ask.
Yeah, so we'll have to think about, I think that, yeah, in our updated planning board and zoning board handbooks, which will obviously include all these changes, we may add some additional language or templates of kind of model language that boards, most of this could add to their rules of procedure. A lot of this kind of talk would go into the planning board and zoning board rules of procedure. Which again wouldn't have to go to town meeting necessarily, though, would just be adopted by the planning board or zoning board.
Oh, and it looks like I'm taking over. So I will pull up my my version of the presentation here. And no, there are a number of open questions. I think there's 40 something at the moment. If you just want to breeze through those really quick. There might be some topics
Sure.
that we didn't hit or that we did hit.
Sure. And you are still in, you're not in full slideshow mode. There we go. Great.
All right. So section 77, fee shifting and bond. So the Superior Court is now allowed to require a bond from the appealing party whenever an appeal is filed. This section also allows a court to award attorney's fees and costs to the prevailing party in certain circumstances. So this does get a little nuanced here, but the way it works is for local land use boards, if the board in making its decision acted with either gross negligence, bad faith, or with malice, then attorney's fees and costs could be awarded to the appealing party. And it would be awarded to the local land use board from the appealing party if the party acted in bad faith or with malice in appealing to the court. So, for example, if the appealing party knows that there's really no basis for their appeal, and that's very clear, it's in bad faith, the court would say, look, this is a waste of our time. and we're going to award attorney's fees to the local land use board. On the opposite side of things, if the local land use board in making this decision, just said, hey, we don't like the developer, and that literally wrote, we don't like the developer in the minutes, or, we just don't like the idea of whatever it is that's proposed coming into town. And you didn't go through the ordinary process, ordinary evaluation process as you would be required to do, then that would be, bad faith, malice, something along those lines. And it's possible that attorney's fees would be awarded to the appointing party. This change goes into effect on August 23rd of this year. Section 78, properties for acquiring properties for workforce housing. This expands the definition of public use under the TIF statute. It allows any party, including a municipality, to acquire real estate for the purpose of constructing housing units which meet the statutory definition of workforce housing. They can't use eminent domain if it's the government. That's specifically barred by the statute. So you would go out, have an ordinary sale. It would not be eminent domain. And then there could be a decision about whether that's going to be used for workforce housing, or presumably that decision will be made before that purchase is made. And that construction could either occur through private development or some sort of private commercial enterprise. So it wouldn't be restricted to necessarily who went out and bought that, whatever entity went out and bought that property. Again, this goes into effect August 23rd. One thing to note, that this provision does require specifically require a vote of the legislative body. So a town meeting vote for most of you. For cities, it would be, a city council vote to authorize this expenditure, but that would occur in the case of any sort of expansion of TIF districts anyway. Section 79 also deals with TIF districts. It allows municipalities to designate specific TIF districts for the purpose of acquiring, constructing, reconstructing, improving, altering, extending, operating, maintaining, or promoting residential development. So basically, any sort of residential development could be the subject of a TIF district. So your municipality could decide, hey, we want this certain area of town to be residential. We want to give certain incentives there in order to promote housing. And I want to note that this isn't just for workforce housing. Any housing project would qualify under this particular section. It's not limited to workforce housing. Again, this would also require a legislative body, town meeting, or city council vote to be brought into effect. And this change also, earliest you could cause it to go into effect is August 23rd of this year. With that, we have very briefly wrapped up 1661. So Noah, are there any questions on those three sections that I covered?
So I'm not seeing additional questions on your three. I do gonna go hit a few more of the earlier questions, if that's okay, before we transition to House Bill 1021. And I'm getting a note that we're not in full slide view.
All right, let me.
So I am seeing presenter view. I'm not sure what everybody else is seeing.
Of course. Let me see if I can switch that. Helpful. So let me see if I can get this to display correctly. And I apologize to everyone for this slight delay. Are we going to do this? Hopefully you are now seeing the correct view.
So we are still seeing in your PowerPoint. not in full slide view. There you go. That looks correct.
All right, sorry.
If you're having trouble, Natch, I'm happy to go back to my version. And you can just tell me when to advance if you want to do it that way.
Yes, sorry about that. Is it working now?
No, we are still seeing your in PowerPoint like version, like layout view, not full
Okay.
slide view. There you go. That's correct.
All right. Well, as I said, we unfortunately had some issues today. So anything else you want me to cover about 1661 or anything you want to follow up on, Noah?
Yes. So we did just get a question. We were getting more findings of fact questions, which I'll come back to in a minute. I want to go back to an earlier question about the tests on section 70. If the planning board or zoning board member does not use a test or fail the test, could this be used in the future against a test should a lawsuit occur by claiming the board members are not qualified to make decisions on land use matters? No. The testing requirement was left in there as a vestige from a earlier version of the bill when at one point testing was going to be mandatory. It is just a carryover of to the final bill, totally optional. There were no legal ramifications for a member failing the test or not taking the test at all. So that is that one we took care of. There's a question here about the incentives, elderly housing incentives, or any of the incentives for elderly housing. Do those include tax exemptions? No, these would just be incentives under the land use statutes. So dimensional requirements, density requirements, timing, phasing incentives that are within the zoning ordinance or other land use regulation. The elderly housing tax exemptions, my understanding, is a different part of statute, which this section 72 does not touch.
This is really just geared towards making them easier to build fast, both in terms of sort of relaxed requirements as well as kind of a faster process.
And then there's some question about fees for peer review. And I know we've gotten questions about that you don't know the fee up front. So these are, and I know this did come up in prior versions of the bills. The section 71 on fees are really fees that can be predetermined. So if there's a fee that is, because the board obviously has the opportunity to request peer review at any stage, and you're not always going to know what fee that is going in. That's, you can't be required. There's no plausible way for a community to set out what that fee structure is for some fees ahead of time. For those fees, those would not need to be part of this publication of fees. However, any kind of application fees, other standard fees would need to be on this one kind of centralized posting notice of land use board fees. Natch, I don't know if you want to comment there.
Yeah, and it may be a good idea as part of this centralized listing to note that you might have those other fees that the amounts can't be determined at this time because it is on the basis of individualized applications before the board.
Great. So I'm going to keep going through a few more questions and then we can maybe switch over to 1021. We are not going to get to all the questions today. I think we will be here for the rest of the day if we do, but I do know that we have OPD and NHMA have discussed kind of possibly creating an FAQ later down the line to answer some more of these questions. So any questions that we don't answer today, and I know we've gotten others, we will kind of put into an FAQ that I think we'll try to get out. I don't want to put a commitment of how quickly we'll get that out, but we'll work on getting that together as well. A few more written findings. The fact question: are written findings for section 73 something other than the minutes? They probably need to be more detailed than what your typical minutes are. Yes, and this is really going to be on a board hearing a case, and kind of writing down. Now, could the written findings be captured in the minutes? Yes, if they're detailed enough. But you know, detailed minutes can really vary from whoever's from one board to another. So I don't want to just say carte blanche. The minutes are going to be always sufficient to satisfy your written findings of fact. They need to be detailed enough, as we laid out earlier. If it's an approval and it's a controversial approval, to be defensible, and in the case of a disapproval, to really be able to explain what parts of the regulation the board was having trouble getting to yes to, and explaining its rationale for that. Another question here on findings of fact: how deep does a town planner get into findings of fact? As it was stated, it does not replace conditions of approval. And we got this question earlier, I think, on Plan Link at some point. So a town planner or staff planner or land use administrator typically, or may in some cases, provide a board with a summary of a case to consider when it's kind of going into hearing an application. We've done our review. Here's what things you might want to consider as a board. Typically, findings of fact, though, are judged on what the board hears during the public hearing, and in addition to the written materials it received from the application. So the findings of fact are really something that need, as we've said, that need to be written by the board itself in conjunction with the board's council, or if the board doesn't have its own separate council, town council. It is not typically something that you can count on your town planner or land use administrator to write. Natch, I don't know if you have anything to add there.
No, yes, it's really the board's responsibility to work with their attorney, if that's necessary, to find what the findings, to make the findings of fact. And I guess the way I think about it is, I think about it in the same way as I would think about kind of a regular court opinion, whether that's from district court, superior court, or the Supreme Court. There are plenty of examples out there. Typically begin with some sort of, here are the facts, the applicant came in to apply for whatever, what's the relevant law? Well, here's the provision in our ordinance that applies, and based on our application of it, the facts as presented, we're denying the application because they don't meet whatever the criteria is.
Yep. A few more findings of facts. As I said, I know there's a ton of questions here and we could do this all day long. What is the timeline for issuing the findings of fact? So the finding of fact goes with the approval or disapproval. So those would be required to be issued after that. It's the 90-day clock or the 90-day clock for ZBA decisions, 65-day clock for planning board decisions. Have to think about what the timeline would be for written findings for other local land use boards, historic district commissions, building code board of appeals, and such. But since we're mainly, I don't know.
And no, I think it's important to relate this back to obviously the timelines. So, at the 90-day period or the 65-day period, the applicant has the right to go to the next step in the process to say, hey, look, I came before the board didn't do their job. And now I'm coming to you, whoever, whether that's, probably the Superior Court, and say, look, and now it's time for you to issue the decision. It says I can do what I want to do. Obviously, if you've had the hearing, if you've made a decision, really the written findings are just encapsulating what you've discussed and decided as a board after that hearing, when you're determining whether it's appropriate for this application to move forward or not.
Right. Great, thank you. And then I know there is a question about examples for findings of fact. You know, we may, like I said, put templates for the language on the timing of approvals. That's pretty straightforward. Language should be added to a board's rules of procedure. We have shied away from putting out specific examples of finding a fact because every application and every case is different. And we really don't want boards to get in the habit of saying, okay, if I've said it's done ABC on written findings, which might have pertained to one case, that's going to work for all applications. And so I totally understand the boards wanting a rubric to follow for written findings of fact, but it's really unfortunately, because of the case specific nature of it, you know, we have decided not to do that. Given town's resource limitations, could a planning board request an applicant to propose findings of fact as a starting point in the case of an approval? I'm not sure this is a best practice, but I think that yes, I don't see a legal reason why that couldn't happen. But I think it could potentially put the board in a difficult position. I would just tread very carefully on letting an applicant prejudge the facts, basically provide the written prejudged facts of a case to the board for
Yeah.
which an approval is going to be written.
So
be made.
I would just add on here, remember that as a land use board, you're a quasi judicial board. You're sitting in the role of a judge, basically. And none of you on this call would want to go in front of a judge that has already made up their mind. So if you're asking, you know, one party to the case to write up the proposed result as kind of the start off point for the case, you already have this situation where it may not be the case that it is biasing the board, but it's certainly going to look like that's problematic. You know, you're even in kind of the legal world, attorneys go before judges, they ask for some sort of specific relief. They say, you know, judge, I'd like, you know, X, Y, and Z. I want an order that says this. Generally, the attorneys don't draft orders in cases. There are some exceptions, but it's generally not the case. And so you're really in this position where, because you're that first court up there, that first judicial body, you're really the one who's going to decide what the actual facts are here. And that's going to be really critical for any sort of appeals. And you want to make sure that you're doing this in a way that complies with your impressions as an unbiased board, rather than the impressions of someone who's obviously biased.
So in the interest of time, I'm going to go through, thank you, Nate, that's helpful. Two more things on findings of fact questions, and then we're going to move on. So folks are saying, how does this differ from what's already out there? So yes, everyone is correct to note that the section 73 on written findings, the existing language in RSA 676:3 Roman numeral run already does require providing written finding of facts. So that is not changing. The part that's new is this ramifications of a failure of a board to make those written findings of fact, specifically when they're supporting a disapproval. And so the weight or necessity of findings of fact now has kind of taken on new weight that it did not previously have for boards. And so that's why I think there's more emphasis here. But no, all these questions that I'm seeing are correct. A board has already had a statutory responsibility to write written findings in the past. It is not new. The other kind of question I'm seeing a bunch here on written findings is, are written findings also apply to conservation commissions? No, they do not, at least under this provision of the bill. Local land use boards definition of local land use boards does not include conservation commissions. So conservation commissions will not be subject to this new language in RSA 676:4.
And on your screen, you'll see the listing of boards that it does apply to.
Thank you. So I'm going to keep moving. I want to see if there's anything towards the end of 16. Most of these are really about fees and finding a fact, which we've gone over a lot.
So Noah, how about I talk about 1021 for a bit, and then we circle back at the end for
Great.
the round of questions.
Sounds good.
So House Bill 1021 is the primarily religious use of land zoning exemption. You may have heard about, it's been discussed, I think, on Plan Link fairly extensively. It's a somewhat short statute, and I'm just going to read it very briefly to you. No zoning ordinance or site plan review regulation shall prohibit, regulate, or restrict the use of land or structures primarily used for religious purposes. And then there's a second clause that provides an exemption, which says, provided, however, that such land or structures may be subject to objective and definite regulations concerning the height of structures, yard sizes, lot area, setbacks, open space, and building coverage requirements. And then there's a third clause that provides an exception to the exception, which says, as long as said requirements, meaning everything I just listed, are applicable regardless of the religious or non-religious nature of the use of the property and do not substantially burden religious exercise. So how did this come about? Well, it's really modeled after Massachusetts Dover Amendment, and the link here is going to go to the Massachusetts Municipal Association's page. They have a whole page about the Dover Amendment and how that functions in their state. Obviously, our statute's new, the language is different, and there haven't been any cases on it yet because it only went into effect on July 1st. So we don't know how closely our courts are going to parallel any of Massachusetts. But I did want to bring this to your attention because I did think it was useful to just look at kind of the history there and understand it and how that has been applied, because it also highlights some of the concerns that may arise, issues that may have to be resolved by the courts. So what does the statute do? Well, it overrides most municipal limitations for land or structures used primarily for religious purposes. It's silent on state and federal regulations, so all of those still apply. Obviously, you know, we as a state can't overrule federal law, so those would apply. And then any kind of state regulations pertaining to land would continue to apply as well. This just pertains specifically to municipal limitations. And the new law would likely permit site plan review that's limited to controlling the heights of structures, the yard sizes, the lot areas, the setbacks, and building coverage requirements, all of those things that were listed specifically in the law. Again, provided that exception regarding the substantial burden of religious exercise does not apply. You should also be aware, if you're on a planning board or you're interested in planning boards, that other site plan review requirements, such as lighting, signs, noise, on-site, off-site, drainage, erosion, sediment control, layout of streets and sidewalks, etc., would not be applicable to qualifying religious properties. So those other things that might be in your site plan review that are required, those properties would now be exempt from those. But again, I just want to emphasize that any sort of local enforcement of state and federal laws, such as compliance with the state building code, the state fire code, your regulations for driveways, the septic and sewer regulations, shoreline protection requirements, wetlands, all those environmental regulations continue to apply to the properties. So if someone comes in with an application, it otherwise qualifies for this exemption, but it's being built on a wetland. Obviously, the wetland, state wetland requirements would still control, and the an applicant would have to comply with those. So there are some questions as to what some of the terms used in the statute mean. I read the whole statute to you, and so you know there is no definition section. One of the questions is, what does primarily religious mean? It's something that has come up a number of times from a number of municipalities because there's no definition within the statute. Because of that, it's likely that the terms are going to be used in their common usage, in their dictionary definition, because that's how the New Hampshire Supreme Court, the US Supreme Court, and every other court understands normal language to function. It means what it ordinarily means, unless the legislature has defined it differently. So primarily is going to mean mostly. It's mostly used for a religious purpose. I can't tell you what the scope of mostly is going to be, whether that's, you know, most of the land, most of the time, or something else. Obviously, if you think of a traditional religious purpose, let's say a church, you know, the church exists on whatever its lot is. It may or may not be most of that lot. Primarily, it's used for religious services, and it's probably not used, you know, all the time, you know, 24/7. It's used really, you see people there Sundays, you see them Wednesdays, you see them other religious days. And that's when you see them, and that's probably where we're going with the term primarily. We do want to point out that there is a statute that exists in the property tax exemption section, RSA 7223 Roman 3, that exempts religious real estate from property tax. It actually has a definition in there for what qualifies. I do want to be very, very clear here that although there is this definition in statute, it's a totally different section. It's the property taxation statute. It's not necessarily going to pair up one-to-one with this exemption. So it may be helpful to look at this definition and say, you know, whatever's being proposed checks one of these boxes. Therefore, it probably qualifies under this zoning exemption. But just because it doesn't qualify for the property tax exemption does not mean that it would not qualify for the zoning exemption. So to restate it another way, because I am a lawyer, so we like to say the same thing 5 times in different ways. Something may qualify for the property, for the zoning exemption, but not qualify for the property tax exemption. So it's important for you to keep that in mind, but it is something that we thought would be useful to point out because, again, it's the phrase primarily religious purpose is not defined, and certainly we can talk about all sorts of examples. Something obviously is a religious purpose if they're building, you know, the traditional synagogue, mosque, church, whatever. If it's something that is going to have sort of frequent prayer groups or prayer groups at some frequency, but it's also primarily or also used as a store or someone's house, there's going to be some question as to when something becomes primarily religious in nature. There's some other complications with this statute as well. The term substantial burden is not defined by the statute either. I do want to let you know that this term has been looked at by the federal courts previously. I assume the same definition would apply in this case. So just to one example is a case called Roman Catholic Bishop of Springfield versus City of Springfield. That's from the First Circuit in 2013. And they looked at the phrase substantial burden and said, you know, really the definition is a burden is something that hinders or oppresses, or something oppressive or worrisome, and something substantial is important or significantly great. And then the First Circuit which is our circuit, went on to explain that there are some factors helpful in determining whether a particular regulation proposes a substantial burden. And there are three factors here. One, whether the regulation at issue appears to target a religion because of hostility to that religion itself. Two, whether the regulation was imposed on the religious institution arbitrarily, capriciously, or unlawfully. And three, whether local regulators have subjected the religious organization to a process that may appear neutral on its face, but in practice is designed to reach a predetermined outcome contrary to the group's requests. Now, totally separate and apart from that analysis, which took place under the US Constitution, there's, of course, New Hampshire's Constitution, and our Supreme Court has also looked at the phrase substantial burden. So looking at State v. Mack, which came out in 2020, our Supreme Court said that it really boils down to when a governmental land use regulation substantially interferes with a religious practice in the context of a land use regulation that must be necessary to achieve a compelling government interest. That's a little bit of a different test. It does get quite complicated in the legal realm. So if it's going to be a question for your board, this is why we're recommending a review by town council to see whether there is going to be some claim of substantial burden that's going to be problematic or not. And we, as part of this presentation, have given you a couple handouts. One Noah mentioned earlier, it was a comparison between provisions of the statute previously and the new statutes. And the second one is a joint memo that we wrote with BEA about all of the stuff that we've covered today. And as part of that, there is a sample affidavit at the very end that we would suggest that your municipality start to use for anyone who's coming in to say they're building something that would fall under this new zoning exemption. So essentially what they would do is just affirm via this process that they think that whatever their application is would qualify for this exemption. It would then be up to the board to look at that to determine whether it did qualify or not. And that's going to be an individualized analysis, but that might help clarify things, because you don't want to be, at your public hearing with the applicant, explaining what their project is, and then all of a sudden saying, hey, this would apply for this exemption. And that's not something your board is prepared for. Obviously, we want board members to be prepared, or as prepared as they can be. And certainly, this will help you in your lead up to that hearing, figure out what type of questions you want to ask, have the opportunity to consult your counsel, your attorney, if you think that's necessary, as well as look at whatever regulation may pertain to the application and determine how it relates to this new exemption. So I'm sure there are questions on all of that.
Yes, there's a bunch of questions. So let me see if we can run through some of them. Go back to here. So there was a couple of questions, Natch, about whether federal MS4 stormwater regulations could still be applied and be enforceable in the review process for these primarily religious uses.
Again, any sort of federal or state regulations would continue to apply. This exemption just applies to your local regulations.
Okay, and great, thank you. What if, another question, what if religious structure is only permitted in a particular zone by a conditional use permit? Would this now be prohibited under this new statute?
So if a religious structure is only permitted in a particular zone, again, we're going back to the question of substantial burden. Realistically, what we're probably looking at with this statute is that if someone wants to propose something that's primarily religious use, it's probably going to be allowable in any zone in your municipality. And that was really something that was discussed during the public hearing. It was something that was the proponents of the bill were interested in making sure that was the interpretation.
Mhm.
And I see that there are a number of questions about things like, what about a facility running a firing range?
Yeah.
Or I assume there are questions about housing, soup kitchens, etc. That's something that we've discussed quite a bit. It's one of the problems with not having a definition of religious purpose is really, it's really hard to nail down. I mean, it's because what someone considers a religious practice might not necessarily be what other people consider religious practices, and it has to be some sort of sincere belief, and that's really the extent of a definition I can give you. And part of that may be, ministering to the poor is a pretty common religious practice, and that may cause some group to propose something like a soup kitchen, or propose, whatever the case may be. If the Mandalorian comes to town and proposes a firing range because their religion is their weapons, I can't give you a definite answer as to whether that's something that would pass judicial review or not.
Great. And we got a clarification, which I think from Jen says which is correct, that MS4 requirements, while federal, are placed upon the municipality, who in turn enacts local stormwater regs that they have to enforce. So does that change your answer, Natch?
I'm going to have to do more research on that, just because I'm not as familiar with that, and I'm just going to have to get back to you on that particular one.
Great. And folks are looking for the link, so I'm putting the link to the joint advisory. I just put that in the chat. Hopefully everybody got that. We'll make sure to get the links out again to the summary, the HB 1661 comparison table, as well as in a guidance one I just put in the chat. Let's see. Okay. If a church purchases a lot of land for a parking area, is that development now exempt from site plan review?
Well, I think this is really the context where a lot of this is going to come up in, is parking. And it is the case, really, that your site plan review that is not sort of a focus on any sort of state or federal regulations are really restricted to what's in the statute. So you can have objective and definite regulations concerning height of structures, yard sizes, lot area, setbacks, open space, and building coverage requirements. But that's it. There are no other sort of local regulations that you're going to be able to enforce. So it's very important to keep that in mind. And again, you can only put those in force as long as it's not substantially burdening that religious exercise. So, because that's going to apply pretty universally, I don't think anyone has any sort of zoning ordinance that has one of these things that specifically targets religious structures. But assuming that's applying universally, you're not going to be able to regulate anything other than those, was it 5 things that I listed?
Right.
Mm-hmm.
Great. Okay, we talked about that. There's a couple questions about lighting as well. I think it's kind of the same general kind of
right
refers back to the same thing that you just said. Julie says no can a local wetland buffer be enforced?
I'm just not that familiar with wetland rules, and the different authorizations. I know there's some local authorization versus state requirements, so I really have to do research on that. But since you mentioned lighting, I'll just say again, lighting is something that would not be able to be enforced. Really, when we're talking about things like that, you just wouldn't be able to enforce it. And we do have a short list in this guidance document of things that you would not be able to enforce that are commonly at issue.
Right. Talked about parking already. Again, parking is not one of the listed issues. So you could not consider parking is basically exempt from this review. I will just say that as I think people are picking up on here, this creates a huge exemption. There is no two ways about it. The ability for anybody to assert a religious use now to just get around zoning because there is no definition for religious use, as Natch has said, it creates a very big potential loophole, and I think we're just going to have to kind of wait and see how applicants decide to take advantage or use this new law. I would not be surprised if we end up seeing some legislation in next session that kind of, once the effects of this are more evident, that kind of tries to constrain that. We'll have to wait and see. But certainly in its current form, as everybody has picked up on, probably going to see this takes away a lot of power from planning boards when dealing with religious land uses.
Yeah, and I think one of the things that we really emphasize and that people are certainly picking up on in our questions is there are a lot of questions about terminology used in this particular exemption, what this all means. I agree with you, Noah, that I think it's very likely we'll either see legislation to clarify this, and we'll see where that goes, or it's very possible we'll see court cases because it's simply an open question. I think that's the fair assessment, is it's an open question as to what some of this means, and until we get some rulings from the New Hampshire Supreme Court, unless the legislature clarifies it, we're simply not gonna know what the best advice is in some particular instances.
Yeah. Just trying to see if there's any more big questions that we haven't hit on here on religious. I think we've hit on most of the big questions here. I did want to clarify something I said earlier on the findings of fact section of House Bill 1661, which were that I erred in saying that written findings of fact are already required in statute. Somebody did correctly point out that no, only actual writing out a decision and the reasons for a denial or approval are actually in statute. However, best practice had kind of already dictate that when you're writing prior to this new statute taking effect on August 23rd, when you're writing your reasons for a denial or approval, as statute currently says, best practice would suggest that those should be based in some kind of establishment of the facts or written findings of fact. So while it was not legally on the books, and this does definitely create a new requirement, or it could be seen by some as a new burden for boards to comply with, we would argue that we are not, if you're doing it the right way to begin with, this shouldn't be There'll be somewhat of a increased lift or requirement, but not totally not a total change of how business should have been conducted previously.
And I would agree with you, Noah. I don't see this as significant change, simply because if you were following best practice before, you were already hitting all of these things. If somebody didn't like what you said, what your decision was of your board, and they appealed it, whoever that appellate body was already was able to look at what your reasons were for the denial and understand it and evaluate whether that was proper or not.
Questions are still pouring in, so we'll take a few more. I know we are well over the 1 o'clock mark, and we probably should wrap this up rather soon. I know that there was a question earlier that we got prior to this webinar about whether already approved site plans for a religious land use are going to be enforceable with this new law. Natch, I think you replied in writing to that person, but if you want to comment on that on this webinar a little more, that would be helpful.
I did. So we discussed that here at NHMA, and our opinion was that this law, like most other laws, would be prospective. It would not be retrospective. So generally, if the legislature wants something to apply to already existing things, they would write that in the law, where there'd be some indication that was the case. We weren't aware of any indication. We certainly didn't see that in the law. It's very brief again. And in looking at the tests required by the courts as to whether something would apply in retrospective and whether that would comply with the New Hampshire Constitution that generally prohibits retrospective laws, our thought was that there may be vested rights there that could potentially be violated. So if you think of something like a condition subsequent or something like that, that you would have the ability to enforce prior to July 1 of this year versus on July 2, that would be the question. There were obviously, the municipality had that right to begin that enforcement proceeding to continue with that. So we think there are vested rights there, and that would be our thought about it.
Great. There's a couple other questions about kind of intent on 1021, and whether things are really, lighting is really a burden or not, constitutes a significant burden on religious use or not. We can only really comment on how the language got drafted and approved. They chose to make certain carve outs for some things and not others. Natch, I don't know if you have anything else to say there.
Yeah, I mean, if you're interested in the legislative history, the legislature has really moved to much more access to that online. You can certainly view the testimony on their YouTube channels and see the written submissions. So if you're interested in that, that's certainly available. I was there at those hearings, and really it was kind of the carve out was designed for, people who want to build churches in their town. That's, I think, who came and testified, really. And that was really the thought. There was an example given of somebody who bought a property and started some sort of religious service there and then wanted to build a religious building that wasn't allowed in that particular zone, or there was some sort of zoning issue there. That's the one specific example I recall. Again, that was several months ago and quite a number of bills, so I don't have a specific recollection of it, but certainly it's available if anyone's interested in that legislative history. And it was something that we opposed the full length of the legislature, but unfortunately it did pass.
Right. Okay, and then we're going to do two more final questions here, and then we're going to get to the wrap up couple wrap-up slides. Back on House Bill 1661, can an applicant use up 30 days of the ZBA clock by submitting their application the day after the ZBA's monthly meeting? In other words, can they basically effectively get the ZBA to shorten, knowing that the ZBA is not going to hold another meeting? They're only statutorily required to meet once a month.
Well, people like to try to game the system. So unfortunately, the reality is that even though there's a statutory requirement for a once a month meeting, you really do have to evaluate whether it's appropriate to have more frequent meetings than that based on the requirements in the law.
Yep. There's a couple of questions about at what point is a religious use been abandoned. My understanding is the statute does not address that issue at all.
Correct. And so I think we'd probably have to default to what the general law is regarding abandonment of use. And that's probably what we would look at as an analogy. It's hard to say that that's necessarily the case, though, simply because it hasn't been tested yet. Yep.
Great. Okay. And last question. How does House Bill 1021 work for a project that has been heard, that has had design review, but they haven't formally submitted a full application, but they've been in front of a planning board for design review? Does this new legislation apply? Have they gained their vested rights by going through design review effectively?
I think that the new statute would apply in this particular case. When we're talking about the vested rights, presumably they've gone through the application process. There's already been an approval with certain conditions attached to it, whatever the case may be. If they're still in the process, the only thing we're really changing effectively is the process, which is there's an exemption. It's not changing someone's rights that already exist. So that's where we are, I think, with it having just gone through design review.
Right. And final correction, yes, there is no requirement, again, that ZBA meets monthly. This is back to the prior question, but that is kind of the best practice. They should, but that is not to say that there are plenty of zoning boards that only meet when they have applications before them.
I said that, and then I thought, nope, that's the planning board. And so I'm glad someone pointed that out.
Yeah. Yeah.
So Noah, do you want to talk about investing?
Sure. Yep. Great. So we're gonna one more little kind of promo, and then we will wrap up. So last week, some of you might have heard the Invest in H $5 million planning and zoning grant program launched with the goal of providing funding to municipalities to make regulatory changes to incentivize housing production at the local level. Full information about this program can be found at www.nhopgrants.org. The program consists of 2 different grant programs: the Community Housing Navigators, which will be up to 6 grants for municipalities to hire staff for up to 2 years to help advance regulatory change that is intended to increase housing supply and to undertake community engagement efforts and assist developers and others with facilitating housing development. The other program within this grant program is the Housing Opportunity Grants Program, or HOP grants, which are grants for municipalities to hire consultants to help with 3 phases of regulatory change to increase housing supply. These include grants for up to $25,000 for municipal housing needs assessments and planning, $50,000 for regulatory audits, and up to $100,000 for regulatory development. This program is being administered by New Hampshire Housing under contract with the Department of Business and Economic Affairs, BEA, and New Hampshire Housing will be collaborating with Play New Hampshire, who will be administering the grant program, as well as UNH Cooperative Extension, which will provide extensive community engagement and training to grantees. An information webinar about the program and going through the application requirements will be held next Tuesday, August 16th from 12 to 1 p.m. I'm going to put a link. Hopefully you can see, I will put this link in the correct chat box, and it's also in folks' copy of the slides to register for that webinar next Tuesday, August 16th from 12 to 1 p.m.
So now that you've heard about all the changes, you should get some money to help you implement some of those. And I want to thank everyone for joining us today. We really appreciate it. We know that these are big changes. We certainly are doing, as Noah said, we're going to work on follow up on the questions that all of you submitted today. Certainly over at BEA, they're working on their new publication for, or I guess updated publication for planning boards, and of course the one for zoning boards. Their handbooks there that will reflect a lot of what we've discussed today, as well as a number of answers to your questions. And for those of you attending NHMA's annual conference in November, Noah and I will be presenting on this topic again, giving an overview, and we're certainly going to use the questions that you submitted today as a basis to address a number of concerns and questions that you all have. So again, thank you for joining us today.
Yes, thank you very much. And also feel free to email, put in writing questions to OPD at the email address I've included here, planning@livefree.nh.gov, or as well, I know NHMA has put their email address there as well, nhmainfo@nhmamunicipal.org. We're both here to answer questions.
And Noah, thank you very much for your presentation today. Tim Fortier with NHMA. Just to conclude that I will be putting this into a YouTube video recording. You will receive that link probably by Friday, along with the PowerPoint presentation. And take a look at the email. It will be embedded with the many links that Noah has successfully or unsuccessfully channeled through the chat channel today. So again, follow-up questions to Natch and Noah, but a follow-up email to you all will be coming by Friday. And we hope you take those materials and share them with your municipal colleagues who couldn't join us for this live presentation today. So with that, I'd like to conclude and say thank you, Natch, thank you, Noah, and thank you, our members, for joining us today.